who are loss adjusters at independent claims. Sorry, just had to do that. Janine and Alba both are admitted attorneys with a combined 28 years in insurance, but I won't tell you who they all are. They know their history and they'll tell us all about their insurance experience and their work at UCT Law, and then we'll have a look at the constitutional damages. Take it away, ladies.
Thank you.
Oh, thank you so much, Tove. Yeah, just on behalf of myself and Janine, I would like to say thank you to all of you. Thank you to I2 and Tove for arranging this platform for us, not only to, market our course to you, but also to just share a little bit of knowledge and skills that we have obtained over the past few years. Just from my side, I'm going to basically just tell you more about our casualty insurance practice online course that we are very excited about, that we've recently launched it through UCT's department called Law at Work. What they basically do is they have an online platform where they provide online courses, short courses to the legal industry at large, and that also includes insurance. So just a little bit of background, like Tove just said, Janine and I are both admitted attorneys. We actually studied together many years ago at University of Pretoria, but we never actually met each other then. We only became friends once we joined I2's competitor, one of their competitors, SHA, in 2008. But both of us were admitted as attorneys in 1999. Janine went into a general litigation practice for a number of years, and I landed up slap bang into the insurance litigation department, back then known as Weber Wenzel Bowens, working under Donnie LaRue. Most of you will know him. And I was dealing with aviation insurance, which was a completely foreign concept to me. I mean, and back then, I was completely wet behind the ears. I literally came from a very small firm in Pretoria, where everybody spoke Afrikaans. All my courses, everything at university, all my textbooks, everything was in Afrikaans. So I landed up in an insurance litigation department, and mostly their clients are London based. Most of our clients were from Lloyd's of London, and I didn't even know what an underwriter was. So it was a huge learning curve for me. And what I found is that because you are thrown into the deep end, even with my legal background, even with I did an LLB, everything at varsity, it didn't prepare me whatsoever for insurance litigation as such. I mean, we at varsity, and I understand even nowadays, insurance is a very small part of mercantile law. It's literally a semester or one chapter in your mercantile law textbook where they deal with insurance. And I mean, I like I said, I didn't even know that there was something like an underwriting managing agency. I didn't understand, who a loss adjuster was. I've never heard of a person called a loss adjuster. I knew that there were assessors that went out when motor assessors when you were in a motor vehicle accident, but I never heard of loss adjusters and the career that can be followed in loss adjusting. So it was a huge learning curve for me. And to be honest with you, this is now more on the personal side, it was so overwhelming that I ended up feeling like the worst lawyer ever. I should never have gone into law. It's a very stressful environment. Dealing with liability claims or casualty claims, you're dealing with third parties who were injured, who are angry, who are agitated. They without money, they don't have medical aid, so they can't pay for their broken arm, you know, and all those things. And there's a lot of pressure from the insurer's side, a lot of pressure from the broker's side. So it became very overwhelming. And I was at one stage, I thought by myself, you know what, I should never have gone into law. I should never have done this. Yeah, and I took some time off, and I actually realized, but you know what, I actually have a passion for this. And the seed in me started growing in, I would love to help other people. I would love to upskill myself. I'm going to start reading up, learning, talking to people, getting as much exposure as I can to different types of claims, different types of policies, etc., etc. So yeah, I ended up working then at the then Admiral, just before they merged then with Stalker Hutchison. And that's where Janine and I then became friends. Then I went to Mutual and Federal, and yeah, that was also a different ball game for me. I found that, you know, especially with your larger institutions, when it comes to the liability side or casualty type of claims and policies, a lot of people didn't know what was going on. They didn't understand how the policies operate and things like that. So, and I kept on asking people, you know, isn't there a course? Isn't there a manual? Isn't there a textbook that someone might have written somewhere where I can just go to and go and look for the answers? Because I had so many questions and nobody could answer me. And yeah, and you know, everybody just said, you know, that's the problem. We don't have that, which I found quite surprising, because a few years ago I did some research and I found out that, you know, the financial sector in South Africa is the second largest employer in South Africa, next to the government itself. So the financial sector has got so many job opportunities and you know, scope for many people to apply their skills, but there's no formal training and no formal qualification specifically for short-term insurance. And then also more specifically for your more niche type of products, like your liability covers, your PI covers, financial lines, etc. So that is basically one of the reasons. Last year when the lockdown started, Janine and I were both, we both left SHA at that stage. I was already working as a loss adjuster, and I said to Janine, you know what, if we don't put something now together, we're never going to do this. And you know, and that's been, for us, it's been a big frustration, especially when we were working as claims managers, and Janine was the executive head of claims at SHA. And that was the biggest frustration. We employed new staff who had all the qualifications, they had all the skills, but they didn't have the necessary skills to do the job and to understand the policies. And we found ourselves completely overwhelmed as managers to try and upskill them as fast as possible, and to get them to just go ahead and go and work independently. So that is basically one of the, you know, the main reasons why we started with this course. So I don't want to take up too much of your time, but yeah, so we then landed up, we literally sent out 2 emails. One was to UJ, and the other one was to the legal department at UCT. And UCT came back and said, listen, you need to speak to this lady at UCT's Law at Work division. And when we started talking to her, she was the director there. And we found out that she was actually also in the insurance industry before she joined the UCT. She knew, you know, she knows exactly what the industry is all about. And yeah, and we then put this whole course together. So just to go to the course, I just want to share my screen here with you. So this is the you know, first of a kind in South Africa. There are no similar, well, even you know, normal courses, like normal qualifications or at universities. There are no courses in casualty insurance. So this is a first of a kind in that regard, but also a first of a kind being a fully online course. I just want to say also just from upfront, the course is live at the moment, so you can register anytime. There is no closing date or whatever for the registrations, and you can do it at your own pace whenever you have time, at home, after work, over weekends, or whenever you have the time. You can complete the course at your own time. Yeah, so we just want you to finish the course, complete the course within 1 year, because there are going to be constant updates as legislation and other things you know, come in. We would like to update the course every now and again, so we don't want you to sit you know, working on the course for 2, 3, 4 years. We want you to complete the course and then move on to the next one. And that is also what I just wanted to mention before I forget. This is the first of a series of courses that we are intending, what we're planning to roll out within the next few years. The next courses are going to be a little bit shorter, and they're going to be more focused on specific types of covers that you get within the casualty space. So we are going to do a very much more intensive course on all your products liability range of covers. So it's products liability, inefficacy, products recall, products guarantee, etc. So we're going to do a course on that. We're going to do a course also on claims, on casualty claims, how you deal with a casualty claim from cradle to grave. And then also we want to do more intensive courses on, for example, your built environment, your architects, your engineers, your quantity surveyors, etc. We're also looking at doing something for MedMal, maybe attorneys PI, and even brokers PI as well, because we also found that, you know, there's a lot of broker PI claims where often brokers even don't understand completely how their covers operate and what types of cover they need to take out. So yeah, so going back to the course, I'm going to share my screen here now. Once you are registered and you've paid for the course, you get a login link. You get onto the University of Cape Town's platform with your dashboard, etc., where you will then see that, you know, your casualty insurance practice course is then loaded on there. So just to give you just an example here, you will see we've got a little overview. Then we've got our different modules. We've got a whole index here on the side, and you can literally just click wherever you want to go, wherever you left off the last time, you can just go and continue there further. Each module, there are 10 modules. The module 3 is just split into 2 parts because it's quite material intensive. There's quite a lot of material in that module. So we split that up in 2, and each module has got an introduction. Let me just show you there, and then your head little subjects or your little chapters inside each module. It has an additional resources tab that you can also look at, where we have basically built-in links to all your acts, to case law, to YouTube videos that you can go and look at of cases where casualty insurance claims were involved. Yeah, so there's a lot of additional resources then. And then if you go back, you have also, each module has got a quiz or an assessment that you need to complete. You have 3 attempts to complete the quiz. And yeah, so it's basically more, you know, multiple choice type of questions. And then there's a few case studies and true or false questions, etc. So yeah, that is basically what each module looks like. Then the text itself, or the material itself, is then amplified by different other functionalities. I'm going to give you an example. We have, for example, we have a number of infographics. If I can give you an example here in the part 2 of the 3 main sources of legal liability, we have under the Consumer Protection Act, we've got all the necessary text that you need to understand. We give little blocks for definitions that we find in acts. And then there's also the infographics basically serve as a summary or as a little chart, or what do you call it, a mind map, just to set out all the different concepts that you've learned under each module. There you will see there's an infographic about product recall, what is important to understand when there's a product recall. Yeah, so that's basically the infographics. But you know, it's very user friendly. If we can give you another example of, we had a few industry experts, some of our panel attorneys or attorneys that quite well known in the industry, to make us some videos on certain specific topics. For example, under the Occupational Health and Safety Act, we asked Mr. Richard Hole, he's from Cox Yates Attorneys, just to do as a short video about how does the Section 32 inquiries under the OSH Act, how does that work? So if I can just play this video. Just for a...
Hi, I'm Richard Hole. I'm a partner at Cox Yates Attorneys, practicing in Johannesburg and Durban. I've spent about 25...
Okay, and then there's also animated videos, which I would like to show you, where we just illustrated certain concepts. Like, for example, on the definition of vehicles and mobile equipment, we found that there's a lot of confusion often. When is a vehicle considered to be used as a vehicle, and when is it being used as a tool of trade? So what we've done there is made a little video to explain when is a vehicle being used as a tool of trade and when it's being used as a vehicle.
The insured owns a cherry picker, which is used for fixing municipality streetlights. The cherry picker is usually driven on the road between streetlights, where it stops, extends its lift, and after the technician...
Okay. Then the last thing I just would like to show you is there's also some flip cards, which we often use just to illustrate to certain concepts, where we give a definition. We have a concept in the front, and then there's a flip card that shows you what that concept means. And then we also have, with our policy schedule, for example, Module 6 is about the common features of casualty policy documents, where we basically discuss what the preamble is, what the policy schedule is, policy wordings, proposal form, what does endorsements mean, the phase disclosure notice, etc. Now, if I can just give an example with the policy schedule, what we've done here is we've used two top types of policy schedules. We used a PI policy schedule and a liability policy schedule. And then where each concept in the policy schedule is then explained in more detail. For example, you will see we've got here professional indemnity with just all mock-up policy schedules. And with the, sorry, I just have to move this screen of mine a bit. Then there's these hotspots that you can click on. So for example, if you want to know what does the period of insurance mean and what's the effect of a period of insurance, then it talks about the policy trigger. What is the difference between a claims made and a losses occurring policy? And we give certain examples with timelines to show you which policy will respond if the claim was made within a certain period, and the policy incepts during another period, etc. So yeah, there's a lot of information, and we hope that this was, you know, we tried to illustrate it as best as we could, just to show people, you know, and explain to them, you know, things like, for example, retroactive date, and what is the difference between a retroactive date and an effective date, or the inception date, etc., etc. So yeah, that is basically yeah, the course in short. As I said before, we have asked Tove, she has the contact details. UCT does all the registration for the course itself. So the contact details for the relevant person, her name is Don Covey. She does all the registration and the administration behind the course. So yeah, we will send through all the contact details and the information through to you after this presentation. Yeah, and I'm hoping that it's gonna, you know, serve the purpose for what we try to achieve with this course, is just to upskill and to make this information available to everybody, so that, yeah, and especially our new entrants into our industry, you know, it's a great course to put them on, so that they all know, you know, what a retroactive date is. If they are in a meeting, they immediately know what people are talking about, because I think that was one of my biggest challenges. Is I sat in meetings, you know, being wet behind the ears. People talked about aggregation and retroactive dates and things like that, and I had no clue what they were talking about. So I really hope that this course will definitely upskill our staff and make us more productive and effective quicker. So yeah, thank you for your time. We are going to, sorry, just before I go, we're going to just answer any questions that you may have after Janine has finished her presentation.
Hi, everybody. Okay, so I am going to do a short presentation. I've got about a half an hour. And what Alba and I thought, you know, after Alba has introduced the course and the platform functionality to you, what we thought was that we would take one of the topics that we covered in the course material and do a presentation for you today, just to illustrate to you as well that what we've tried to achieve in the course is to have a practical application of the concepts that insurance practitioners need to work with on a daily basis. So we've tried to make the course more of a vocational training course rather than just, you know, a legal course, because there are courses out there at universities if you want to become a lawyer, or if you want to train as a paralegal. But what we wanted to achieve with this course is really to bridge that gap between other types of formalized training that you can receive at a university and the actual work that we as insurance practitioners have to do on a daily basis in the job. And that's where we found there was a gap. So we've decided to use one small topic that's discussed in the course, and we're going to do a little presentation on that today so that you can just see the practical approach that we've tried to follow in this course. Okay, so I'm going to share my screen with you. I've done a very colorful presentation. I like everything to be very colorful. So hopefully you won't fall asleep. Okay, can everybody see my screen? Okay, so the topic that I'm going to discuss with you today is the topic of constitutional damages, and you'll see I've introduced it as an emerging risk, and we'll get to why it's an emerging risk. So in the casualty space, as you will all as casualty practitioners be aware, it's extremely important for us to be looking ahead, to be plotting the risk landscape, not just how it looks today, but actually to be looking 2, 3, 4, 5 years ahead, because we are working in a long tail environment. And the reality of our environment is once the risk landscape has changed, if you haven't already reacted to the changes in the risk landscape, it really is too late, because we are working in an environment where what we do today will have consequences years into the future. And I think constitutional damages is one of those areas where it's starting to emerge that there's possibly a new risk on the horizon that we should all at least take note of and start focusing our attention. If you're a broker, focus your attention on how you are assisting your clients in managing their risk portfolios. And if you are an underwriter, you should be looking at this from the perspective of how you want to underwrite these risks and whether you want your policies to respond to this risk or not. Now, I've introduced it as an emerging risk, but it's a bit tongue-in-cheek because the remedy of constitutional damages has already actually been around since the advent of the 1996 Constitution. And it's actually Section 38 of the Constitution that provides for this new remedy. And Section 38 really says, in a nutshell, that where the rights enshrined in the Bill of Rights are infringed, a court may grant appropriate relief to a person who has been affected. And it's this issue of appropriate relief that really has created a lot of headaches for our courts, because as you will appreciate, appropriate is such a moving target. It's really something which to a large extent is left open to the discretion of the courts to determine in each situation what is appropriate for a court to give as relief to a claimant. And that's not something that sits very comfortably with the casualty insurer, because casualty insurers tend to want to understand what the risks are. We don't like uncertainty in the portfolio. So to understand why constitutional damages is an issue, I think you need to understand exactly how casualty insurers and casualty policies traditionally deal with the issue of damages. So I'll take you through a few things today. I'll take you through what the law sees as damages, how liability policies traditionally deals with issues of damages, what constitutional damages are and why they are different from, or may be different from, ordinary damages awards. We'll look a bit at what our courts have recently said about constitutional damages, and then focus ahead and plot the course as to what insurance practitioners should be looking at when they are investigating this whole issue of constitutional damages. So you'll all be aware that the concept of damages is found in the operative clause of your casualty policy. Not all casualty policies use the same language. So some casualty policies will use the word compensation. Some will even use the words compensatory damages, but essentially it all boils down to the same thing. And in simplistic terms, when you are looking at damages, it really is an award that tries to compensate by paying or awarding a monetary amount to a person who has been wronged by another person. But not, the courts, while they try to make good where someone has suffered a wrong at the hands of someone else, There are many different ways to achieve this. It's not only through a monetary award aimed at compensation. So courts can offer different types of relief. They can, for instance, offer specific performance, and traditionally your casualty policies won't respond to specific performance claims or specific performance awards. You do have some casualty policies, such as in your construction space, your rectification policies, which will offer money to the insured to perform in terms of a contract. But traditionally, a casualty policy wants to respond only to damages or compensation orders by a court. Courts can also award restitution. And that's typically in a scenario where somebody has received something from a contract that they're not entitled to. It could be, for instance, your enrichment claims, where you've received benefits that you're not entitled to, or in terms of a contract that might have failed, or one party performed in terms of that contract, but the other party hasn't performed. A court might award restitution to the party who has performed. You also have your punitive awards, usually in the arena of your criminal courts, your punitive awards, imprisonment, to punish someone for the wrong. And that's really one of the topics that we'll explore today, is the whole issue of the punitive element that may come into a constitutional damages awards, because traditionally civil courts are not interested in punishment. That's really the arena of the criminal court. And it's long been a topic of debate in the casualty insurance space, whether there are a thing called civil damages, not civil damages, sorry, civil punitive awards, and whether your casualty policies are geared to respond to those types of punitive awards that might be imposed by a civil court. Then you also have another form of relief called declaratory orders or interdicts, where the court can, for instance, make an order that someone has to do something or stop doing something. Okay, so let's just look at a few recent examples. I know that often, you know, in practice in the casualty insurance space, casualty insurance practitioners look at these things a little bit tongue in the cheek, saying, but isn't this just scare tactics that the lawyers are, you know, pulling a rabbit out of a hat, trying to scare us all? Because are these things real? Now, I can assure you that constitutional damages are real, and I'm going to show you 3 examples that are quite high profile, that you'll all be aware of, which have recently been in the news. And then we'll also just explore, you know, 1 or 2 others where I don't know that there are constitutional damages involved, but looking at the claims, my common sense would tell me that there is probably also constitutional damages awards being sought. So if you will all cast your mind back to about 3 years ago, the Tiger Brands listeriosis claims, we know that Richard Spoor is pursuing a class action there, and we also know that as part of that class action, he is pursuing constitutional damages. And it's interesting in that case, the fact that he is pursuing constitutional damages. You will understand that in the Tiger Brands listeriosis claim, there are possibly 3 types of losses there. You've got your like in this case now, the mother who's saying, I'm so angry I lost my baby. So you've got parents who might have lost a child because the mother was infected with the listeriosis bacteria while she was pregnant. You've got parents who are now having to raise a brain damaged child because the mother got infected. And then you've also got people who died and people who got sick through being infected with listeriosis. And the sad part is, in the case where children have died, the death of a child does not lead to a massive claim. this, and please forgive me if I sound insensitive, but a dead child from a legal perspective is worth much less than a child, for instance, who has suffered brain damage, because your big awards actually come in where there are claims for loss of support, so where a breadwinner has died, or claim for your loss of your ability to earn, your loss of earnings past and future loss of earnings claims. But in the case of a child, of course, that claim falls away. There's no claim for loss of support or loss of earnings. So while it's extremely tragic that a child might have died, the claims that the parents might have in a case like that are really quite small. You'll also remember little Michael Kumape, and we'll look at the Kumape claim now. Little Michael Kumape was the 5-year-old child who died when he fell into a pit latrine at his school and he drowned. And there was also an award for constitutional damages that was pursued there. And then in the very tragic matter of the Life Esidimeni matter, which involved mental health patients that were transferred by the Gauteng Department of Health to various non-governmental institutions who didn't have the facilities, the funding, or the expertise to really take care of these patients. And all of these matters that I've just touched on now are actual examples where constitutional damages were sought. Of course, the Tiger Brands listeriosis class action is an ongoing matter. We'll look at what happened in Kumape and Esidimeni shortly. And then there's also just 2 other claims that have been recently in the news that I would, look, I don't have insight into these matters, but looking at the awards that are being sought, I would surmise that these might also be claims where constitutional damages may be involved. That's the matter of Enoch Mpianzi, who died when he drowned at a recreational facility, recreational camp that was arranged by Parkdown Boys. His parents are seeking 10 million rand in compensation from the Department of Education. And then the very tragic case of Unyenye, who was, of course, the student who was murdered so tragically at the post office here in Cape Town. And in both those cases, the parents are seeking redress. And you can surmise that as these are also children that have died, your traditional delictual remedies couldn't really provide redress to the parents other than for emotional shock, which is quite a difficult claim to prove. But let's move on. So if we look at the legal developments around constitutional damages, and we cast our minds back to 1997, the court in the matter of Fossey versus Minister of Safety and Security considered a claim for constitutional damages. And there the court actually said that it has to be, every claim has to be considered on its own merits, on a case-by-case basis. There's no blanket rule that can be invoked when you're looking at constitutional damages. And constitutional damages may, where it is absolutely necessary to do so, you may use Section 38 of the Constitution to formulate fresh remedies where there has been an infringement of the human rights enshrined in our Bill of Rights. What the court also said, it would only award constitutional damages as appropriate relief where it was necessary to do so. And you can surmise from that that the courts won't likely allow for constitutional damages awards. It's something that's really going to be out of the ordinary. The court also in Fossey said that they would not award constitutional damages as a punitive measure to a claimant who has already been adequately compensated for his loss. And it's interesting because you will see in Life Esidimeni, a different approach was followed. The SCA has also looked at the issue of constitutional damages. They've given us a few rules that will be used where you're looking at constitutional damages awards. The SCA has said you need to look at the nature and relative importance of the rights that are in issue. You need to look at whether there are alternative remedies that might be available. And you'd also have to look at what the consequences are of the claimants breaching these rights. Again, the court said that the circumstances of each case would be important to determine whether constitutional damages are appropriate. And then the court said you would also look at whether there are alternative remedies like a declaration of rights or an interdict that might be appropriate rather than an award for constitutional damages. So if we get to life esidimeni, the life esidimeni arbitration, life esidimeni, the arbitration stemmed from a decision in October 2015 where the Gauteng Department of Health made a decision to terminate a long-standing contract with the Life esidimeni Care Center, who was responsible to look after about 1,400 mental health care patients. And if you go and read Moseneki's award, the arbitration ruling, it's actually quite hard to read it. It's not easy reading. It's Gauteng Department of Health, the decision was essentially driven by the need to save money. And the need to save money in the end led to the deaths of 144 of these extremely vulnerable mental health care patients. If you read the judgment, you will see the extent of the horrors that these people and their family were exposed to. Things like starvation, not having the correct medicine, being exposed to cold, not having the necessary care for these patients. They were literally herded onto the back of open vehicle like cattle and carted off to these facilities. Many of them didn't even have their medicine with them. Their families didn't know where they were. Their healthcare records was lost in the process. And following on this tragedy, the Minister of Health requested the Health Ombudsman to investigate and make recommendations regarding the tragedy. And the Health Ombudsman then said that the government should enter into alternative dispute resolution processes with the affected parties. And that's what ultimately culminated in the arbitration before former Deputy Chief Justice Dikgang Moseneke. And if you look at the words that Moseneke used in the arbitration award, you'll see I've actually taken these phrases out of the actual arbitration award. He used quite strong language. Things like disturbing, arbitrary and random, cruel, inhuman and degrading, reckless and unlawful, dehumanized and callous treatment, torture and trauma. And these words were used to describe both the mindset of the perpetrators and the consequences of the violations to which these mental health care patients were subjected. And Moseneke then, after having considered the extent of the trauma and the suffering, the violation of the rights, and the way in which the government officials who were involved in these decisions conducted themselves, Moseneke came to the decision that the only way in which to vindicate the claimant's rights were actually to award constitutional damages in addition to the normal damages award that had already been granted for the emotional shock and trauma of the surviving patients and their families. So Moseneke awarded it in addition to normal damages, and I think that's quite important. If you look at what we can learn from this, In Isidameni, there was already compensation on a delictual basis had already been granted. So the basis upon which constitutional damages were awarded in Isidameni must have been some other intention by Moseneke, not just looking at compensation. And you can actually deduce from that that Moseneke must have intended to punish the state for the appalling decision that it had made here and the reckless way in which it had treated these people. If you consider also the fact that these people were all dependents, they weren't breadwinners, so their family couldn't have suffered losses other than their own losses, which were vested in their own emotional shock claims. The families couldn't have suffered any losses due to the death or suffering of these patients. So the intention of Moseneke in granting the constitutional damages must have been punitive. If we move on to what happened in Kumape, now I've already said that Kumape stemmed from a horrific incident when a 5-year-old child fell into a pit latrine at school where he actually drowned. And pursuant to this tragedy, the family of the deceased child actually instituted a claim for their ordinary delictual damages, and the delictual damages they formulated as a claim for emotional shock. And then in the alternative to the claim for delictual damages, the parents and the siblings of Michael Kumape also claimed constitutional damages as an alternative. Now, the High Court in Limpopo, after having heard the expert evidence, the High Court came to the conclusion that there was insufficient evidence that the Kumape family had suffered a recognizable psychiatric illness as a result of the emotional shock. And the High Court thus declined their claims for emotional shock. The High Court also declined the constitutional damages claims because the court said if they had suffered emotional shock to the extent that there was a recognizable psychiatric illness or injury to the family, there would have been sufficient remedies in our court available to the family. So the court didn't award either the emotional shock claims or the constitutional damages claim. And this matter then went to the SCA. And the SCA again looked at the expert evidence, re-looked at the issue of the emotional shock claims of the family and came to the conclusion that there was a psychiatric injury and awarded 1.4 million rand to the family of Michael Kumape. Because the court had already awarded the emotional shock claims, the court did not feel that it was necessary to revisit the issue of constitutional damages because the court found that they had been adequately compensated by the emotional shock awards. And in this case, the court also said that it was not appropriate to award constitutional damages as a deterrent or on a punitive basis to punish the state because it simply wouldn't send the correct message. And also it comes back to, if you recall what we said in Fossey, where the court said that in South Africa, it should be recognized that resources are scarce. So where someone has already been adequately compensated by a delictual award for emotional shock, there was no reason to also award constitutional damages on a punitive basis. So what does this mean for us as casualty practitioners? There may be cases where it is appropriate and where a court will actually impose constitutional damages or award constitutional damages, but this will not be lightly done. And where the traditional legal remedies already provide sufficient redress, the courts won't easily award constitutional damages. But then if you look at Moseneke's arbitration award in Isidameni, in that case, the court felt that punishment was appropriate. So really, if you analyze what the courts have to date said, there's two bases upon which a court might award constitutional damages. The one is where there is currently no remedy available at our common law and the court has to formulate a fresh remedy. And then the other situation where a court might want to award constitutional damages is where the nature, the reprehensible nature of the wrongdoer's conduct might be of such a nature that a court might want to invoke constitutional damages as a deterrent or as a punishment for the infringement of the human rights. Now, how does a casualty policy deal with that? Or how do we think a casualty policy might deal with that? And this is where it's going to become important for us to really understand the cover that the policies provide and how the policies are worded. Because the last thing that you want to do as a broker or as a casualty insurer, you don't want to have to sit and trawl through the wording of a judgment to determine whether you're dealing with a punitive award or whether you're dealing with a compensatory award. You must remember that when courts make their rulings, they don't always do so with insurance recoveries in mind. So they're not going to specifically say this is punitive or this is compensatory in nature. And it might be up to the broker or the insurer in each case to actually go through the award to determine whether what the court had in mind was compensating for a wrong or whether the court had in mind to punish someone for their reprehensible conduct. And as casualty insurers, it's going to be incredibly important for us to determine what the mindset of the court was. I think that if the award is made on a compensatory basis, a casualty policy is still going to respond to it. Because like we said right at the beginning, casualty policies in their operative clause use the words damages or compensation. And as long as the award that a court has made in the constitutional sphere still falls within the ambit of trying to compensate or remedy or make good the wrong, I think the casualty policy will respond. It's going to be a different kettle of fish where you have, for instance, like in the Moseneke case, where the intention and the mindset of the court is to punish a wrongdoer for the reprehensible nature of his conduct. I think that's for two reasons. I think once the award sort of enters into the realm of punitive, you are going to fall foul of the concept of damages in your operative clause. Secondly, I think if you cast your mind back to the language that Moseneke specifically used, it's going to be difficult for an insured to argue that those events are still fortuitous. I think in those cases where constitutional damages are awarded on a punitive basis, the nature of the conduct goes wide of fortuitous conduct or fortuitous event. I think it oftentimes will border on intentional conduct, and it definitely often will border on criminal conduct, as we saw in Esidimeni. And then the other thing that casualty practitioners should also keep in mind when you're dealing with punitive constitutional damages awards are that your traditional casualty policy is going to exclude punitive damages. So if the language of the judgment or the arbitration award is of such a nature that it looks like the mindset of the presiding officer was to invoke a punitive award, you're probably not going to have cover for the actual award. You might still have cover for defense costs under that policy. Okay, and that is me, and I think we've brought it in just in time. So I am going to stop the screen share now, and then we can go to questions.
Thank you very much, Janine and Alba. That was very informative. I learned lots today. We've got 2 minutes, so I'm going to quickly go through the questions that we can take. So Carmony is asking if constitutional damages are awarded in addition to compensatory damages, as in life esidimeni, then would you say that the additional constitutional damages falls wide of the cover provided by liability policy?
I think the difficulty is going to be in analyzing the language, because you're going to have two competing interests. I think that the broker and the insured are going to argue very hard that it's a fresh remedy aimed at compensating, because we've seen it's two situations in which the courts have to date invoked that remedy. One is there isn't a remedy in our law at the moment, so we're going to create a fresh remedy aimed at compensation. The other one is, yes, there is sufficient remedy to vindicate the rights, whether that's a delictual or contractual statutory remedy, but we want to punish the wrongdoer. And I think that's where the difficulty is going to come in, because it's not going to be black and white, and it's going to end up with us trawling through judgments or awards and having an argument about what the intention of the presiding officer was when he made that award for constitutional damages. And you're going to have two competing camps there, your broker and the insured, and you're going to have your casualty insurer who's going to say, well, no, it must be punitive. And that's why I'm saying it might be a very good idea for all of us now to focus our attention on this proactively, so that we don't have to have these arguments once a judgment is made in a specific case. So to answer Carmony's question, it's going to be extremely difficult to definitively say, because a judge is not going to say necessarily, I am imposing a constitutional damages award to punish, but he might use language that you can deduce from that language that his aim is to punish.
Thank you very much for that, Janine. I see we are on 11 o'clock. We do have a few questions that relate to the course, but I think that the material that we'll send afterwards will address all of those questions. So thank you very much, ladies, for a very informative session.
Thank you.
It was a pleasure. Thank you.
Thank you. And thank you to everybody that joined us today. We'll see you guys next week.
Thank you. Bye-bye.
Cheers, Toes.
Bye. Bye, everyone.
Cheers, Alba. Cheers, Janine.
Bye.
Bye.
Bye, Toby.
Bye, everyone. Bye.
Bye.